Well, hello everyone, and welcome to this live stream session. If you're just joining us, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm one of the founding partners of the firm, and you can find us across Ontario, BC, and Alberta. And what's the session, you asked? The session you've just maybe stumbled on? Well, once a week, I log on here to talk about employment law, to talk about workplace rights, to answer your questions, most importantly, to answer your questions live about employment law. This is your live employment law session with me, Lior Samfiru, and this is where you get to ask me questions about your workplace rights. And guess what? You have significant rights. You don't believe me? Try it. Ask me a question about your rights and I'll tell you. You have rights if you lost your job. You have rights if your boss is threatening you with something. You have rights if your job has changed or your hours, your compensation. Absolutely have rights if you've been discriminated against. I think you get the idea. When it comes to employment law, workplace rights, there's a lot of those things that you have protections. And on this session, you can ask me a question. So I see people are watching. That's fantastic. I want you to watch and learn and listen. But even better, let's keep it interesting. Ask me your question. If you're struggling with an employment law issue, why not tell me right now what you want to talk about? Why don't you get me to help you with your legal issue? Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And before I start answering questions, let me give you some contact information. If you want to connect with me and my team off social media, off live stream, it couldn't be easier. All you do is you go to employmentlawyer.ca. Again, you see it right here, employmentlawyer.ca. Phone number is right there. So is the email address. All the contact information you can ever need is right there. There's also forms you can fill out if you prefer, and my team will call you. You can also learn a lot more about employment law. So that's kind of your one-stop shop to reach out, to connect with me, to have a private discussion. It's employmentlawyer.ca. Check that out and always remember that address. Tell others about it. Very easy to remember. If you're speaking to a friend, a colleague, a neighbor, and they're dealing with an employment issue, they lost your job, easy. Just tell them, hey, check out employmentlawyer.ca and we'll take care of you. But right now, I'm here, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live with you, looking for your questions. I want you to keep me busy. I want you to keep me on my toes for this session. Get me to answer your questions. Let me scramble a bit. Let's have some fun with this today. I'm going to start answering the questions right now. You have so much time, so you can take your time, have a glass of water as you're thinking about the way to phrase your question, and then type it in. I'll see it. I'll read it, and of course, I'll answer it. All right, so let's see what we've got here. First question today, it comes to us from YouTube, and that's from Graham Marks. Graham Marks says, I'm being let go from my job because we have lost a lot of business due to issues with the US. My employer has said that they don't have the money to keep me on. If they're struggling because of this, do they still owe me severance? Absolutely. This is such an important question, especially these days. The fact that a company is struggling financially does not relieve them of their severance obligations. You still have to get severance. Your employer must pay severance. I'll take it a step further. Even if the company decides to shut down, okay, for whatever reason, they're not going to operate, they still have to pay severance. The only time where you may not get severance is if the company is formally in bankruptcy proceedings, legally in bankruptcy proceedings. But that's not what we're talking about. The company is slowing down. Maybe they don't have money to keep you. Either way, they have to pay you severance. And by the way, that severance is as much as 24 months' pay. So this excuse of we don't have money, no excuse, must pay severance. And I can almost guarantee you, you're going to be surprised, shocked maybe even, by the amount of severance you're actually legally owed. All right, I'm going to give you in a few minutes a tool to find out how much severance you're owed. But what I want you to keep in mind, you lost your job, you're owed severance, you got to give me a call, because your employer is not going to just say, hey, here's the severance that you're owed. We're going to need to push them a bit so that they comply with their obligations. But they will, you will get it. So thank you, Graham Marks. I'm here to help you. My team is to get you that severance that you're owed. So thank you for that question. Excellent question. By the way, I'm going to continue answering questions. But if you've just joined me, welcome. Thank you for being here. I'm Lior Samfiru, the employment lawyer, live with you, answering your questions, making sure that you have answers to whatever legal issue in the workplace you are dealing with. So type in your question. You got time. I'm not going anywhere. Let's make sure we get your answers. I see some questions have come in. Let's get to answering them right now. Blarney Times. Are we going to see any big changes to employment laws in the coming months if the U.S. makes some big promises for us? We might, but that's only if we see significant impacts to the workforce, like we had back when the pandemic hit. So when the pandemic hit, everyone's job was affected, pretty much everyone, whether it's a layoff or a reduction in hours or temporary layoff, termination. So if it gets to the point where it's a massive, it's like a black swan event, yeah, we may see changes to laws. But guess what? Those changes are going to be in favor of employees, not against employees, in favor. I think we're still far away from that. It's impossible to know if that's going to happen, if we're going to see changes, if the U.S. is going to impose tariffs. Are they not? Are they going to be partial tariffs? So time will tell, but it's going to take something major to see changes to employment laws. But either way, you have rights. So if your job is impacted right now because of tariffs, cost cutting, reduction in staff, you have rights. Don't sit on those rights. Let's talk right now about what you're owed. Reach out to me through employmentlawyer.ca, and I'll make sure to help you. Again, that's employmentlawyer.ca. Great questions so far. Let's keep them coming. Again, I'm live here with you, the employment lawyer, Lior Samfiru, answering your questions about workplace rights, employment law, wrongful dismissal, constructive dismissal, harassment, discrimination. I can keep going, but you get it. All right, let's continue answering questions, shall we? Azadi. Sorry if I'm mispronouncing Azadi, but here's the question. Termination from my company in BC. Urban planning designer. I'm 38, on a valid work permit, earn $71,000 annually, without cause. 6 weeks total severance. Can I ask for more than 6 weeks? Zaidi, you haven't given me the most important piece of the puzzle, which is how long did you work there for? So I don't know if you worked there for a month or 10 years. So that's key. Here's the thing, though. Unless you work there a month or two, you're going to be owed more than 6 weeks severance. Okay. Even short service employees are going to be owed significant severance, more than 6 weeks. Usually, especially in BC, severance starts really at 3 months. 3 months. It starts, and it goes up from there. So chances are, if you lost your job, you're owed much more than 6 weeks. Oh, you say that you've been there for 3 years and 3 months. You're probably owed about 6 months severance, not 6 weeks, 6 months. So this is a wrongful dismissal. A wrongful dismissal is simply a situation when you've been let go and have not been paid your full proper severance. So you're let go after 3+ years. You got 6 weeks. You're probably owed 6 months. 5 to 6 months is the right amount for you. So what you need to do right now is you got to call me. All right, you got to reach out to me. Let's make sure we get you the severance that you're owed. If you go to your employer and say, "Hey, pay me more," they're not going to do that. Once we go and they realize, yeah, okay, they called us on it, they will pay what they owe. So to connect with me, Azadi, and anyone else, very simple, employmentlawyer.ca. Look that address right here, employmentlawyer.ca. Make that call or go to that address and let's have that chat. Thank you for that. Very important question. Very common scenario, by the way, what Azadi is going through right now. Was let go and was offered 6 weeks when it should be 6 months. I speak with people every day across the country that exactly that scenario happens to them. Almost every person, when they're let go, are offered less than what they're owed. 90% of people. So don't make a mistake by accepting that offer. Once you sign off on that piece of paper, you can't go back. You can't change your mind. So Azadi did the right thing, reached out, and we know Azadi's owed a 6-month severance. Reach out to me again, employmentlawyer.ca. I'm still live here. You have time to ask questions. Questions have come in. I'm going to answer them, but I want your question as well. I don't want anyone to leave here today without getting their question answered. Take advantage of the fact that I'm here. Again, Lior Samfiru, the employment lawyer. All right, Ali, I should say. Ali has our next question. I was fired last week unexpectedly on my termination letter. It indicated I wasn't getting back to a broker in a timely manner. I have never received a bad review and been told there are many have not been told there are problems in my 9+ years of working there. Am I eligible to fight to get EI since they put fired on my ROE? So Ali, you're actually in a way asking the wrong question, because yeah, of course you can get EI, but the real issue is that after 9 years, you're a significant amount of severance. You could easily be owed a year's pay, and that's separate from EI. The only time a company can terminate you for cause and deprive you of severance and also of EI is if you did something so bad that it's impossible to continue employing you. Now, even if what they're saying is true and that you didn't get back to someone when you should have, that's not even going to be close to justifying a termination for cause without severance. So yes, you can get EI. Yes, you can get severance, which could be easily a year's pay, could even be more than that, depending on the specifics of your job, etc. So here's what you need to do. Easy. You got to reach out to me, okay? employmentlawyer.ca is the way to do that. Again, it's employmentlawyer.ca. Look, it's on the screen right now. Phone number is there. Email address is there. All the contact information that you need is right there. And I'll help you. My team and I will help you get EI, but yeah, also get severance. So the bigger issue here is not even EI. The bigger issue is severance. So yeah, Ali, you say you got no severance. I'm not surprised, but you're owed severance. So you'll get it. You know what to do now. Reach out to me again, employmentlawyer.ca. All right, fantastic. Great question. And I see more questions have come in. Fantastic. You guys are awesome. Let's make sure we get some more answers to you. Next question today is from Orange You Glad. If you work for a U.S. employer as a Canadian, can they refuse to pay severance if their government supports that? Absolutely not. If you physically work in Canada, physically are in Canada and work from Canada, they have to pay severance. What their government says, what their laws in the USA, completely and totally and utterly irrelevant, not relevant. So if you are located physically in the US, then US laws apply to you, whole different situation. If you are in Canada, it's the laws of the province where you're located. So if you work in Ontario, it's the laws of Ontario that apply to you, all right? So that's what we have to keep in mind. And a lot of people ask me that. Well, you work for a U.S. company. Do I care about the laws over there? Couldn't care less. Maybe the company's based in the U.S., maybe it's in Europe, maybe it's in Asia. Does not matter. What matters is where you're physically working. They have to comply with the laws in that jurisdiction. And that's great news, because guess what? We have much better employment laws in Ontario or in Canada generally than they would have in the U.S. So if you lost your job, you got to call me, Orange You Glad. Let's make sure we get you the severance that you're owed, and let's make sure you don't walk away from entitlements that you have. All right, great questions so far, guys. Fantastic questions, in fact. I love it, and I still want more. More have come in. I'm going to answer them. If you asked a question, stay tuned. I'm going to get to it right now. But I want everyone else that hasn't yet asked a question to ask their question as well. I want to get answers to people. I want you to feel better. I want you to know what you can do with your workplace situation. All right, next question right now. Let's see. Next question is from Flo G. Flo G. My boss had humiliated me by trying to give me a verbal warning for missing or being late on replying to emails while I was in the hospital with my kid. And she did it while I was in the office with other coworkers. I ended up having a panic attack and ended up going to the emergency room. I had a initial EKG and cardiac distress. Doctors put me on in 2 weeks medical leave and specifically said to not be contacted because of the cardiac distress and to stay stress-free while undergoing heart test issues. Okay, and the boss wants to put me on a performance improvement plan. So obviously there's ways that discipline can be given. An employer is allowed to give you a warning if it's justified, but of course they have to do it in a way that's not embarrassing and it's not overly harsh. If you think that this employer, this boss has crossed the line, you should speak to HR, because that could be a form of harassment. Okay. And that may be something that your employer must deal with. So at this point, that's the best course of action, is you need to speak to HR and let them know, let them deal with that. Beyond that, at this point, there's not much that you can do, but here's something else. If you're put on a performance improvement plan and you don't agree with it, you don't think it's fair or justified, all I want you to do is I want you to say so. I want you to respond to it in writing. Send an email saying, here's why I don't agree with the performance improvement plan. Here's why I don't think it's fair or accurate, and outline the reasons. Professionally, not in an aggressive way. By doing that, you're going to make it much harder for the company to let you go for cause. Okay? Because if you get a performance improvement plan and you don't say anything, you're going to be considered to have accepted it. And that's going to then potentially be used against you. Don't do that. Respond to it in writing, very professionally, point by point. And by doing that, you're preserving your job and certainly making it very, very, very difficult for the company to let you go for cause. If they do let you go, call me. I'll make sure you get the compensation that you're owed. Okay. Stay off as long as you need to with your doctor support. Come back to work. But also let HR know if you feel that what the boss did crossed the line. Again, to reach out to me, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca to do that. You see that address on the screen. All the contact information you can ever need is right there. By the way, if you've just joined us, I'm Lior Samfiru, the employment lawyer. Since I logged on here, I've been answering your questions about employment law and workplace rights. And I want to continue doing that right now, but I want all the questions I can get. So ask a question if you have an issue. Ask a question if you don't know what your rights are, and let's make sure that we get you the help that you need. Again, I'm Lior Samfiru, and let's get to some more questions right now. Azadi has a follow-up question. Azadi asks, could you advise if you're able to work on a contingency basis where your fees would be paid only if we secure higher settlement? Yes. In the vast majority of cases, we work on a contingency basis if that's what the person prefers. We don't force it, but if you prefer, yes, that's how we do it. Probably 80% of our cases, that's what we do, because we know it's difficult to pay us up for hours and hours of work. So yes, we take that risk, and we only get paid when we're successful. And keep in mind, even in that scenario, one of the things that we do is negotiate compensation for legal fees from the company on top of your severance or on top of the other amounts. So the idea is, when this is all said and done, some of the fees at least will be paid by the company. So keep that in mind. Don't be afraid of the process. Don't be afraid of the legal fees. That's why we have that system. And reach out to me and my team so we can help you. Again, employmentlawyer.ca. Employmentlawyer.ca is the place to go to. All right. Loyal, I don't even know how to pronounce it. Loyal has our next question. My employer has put me on a performance improvement plan. It made up something about performance issues, but I have never had problems before. Can they use this to just fire me for cause? So it takes a lot to fire you for cause. As I was saying earlier, it's not enough to show that you did something wrong. It's not enough to show that you're put on a performance improvement plan. They really have to show that you did something that's so bad, so terrible, that they just cannot employ you anymore. So doing something wrong does not equal a termination for cause, not even close. Look at the termination for cause as the capital punishment, the death penalty of the employment relationship. So it's reserved for the worst offenders. Now, if you're put on a performance improvement plan and it's legitimate, you agree with it, all you can do is do your job, do the best that you can. And of course, if you're let go, you call me immediately. If you don't agree that it's legitimate, as I was saying earlier, if you don't think it's correct, or there's facts missing, or it's not a reflection of what happened, then I want you to say so. I want you to send an email to the person that gave it to you and say, here's why I don't agree with it. Here's some facts you didn't consider, or here's some other information that you need to have, or here's why it's not accurate. By doing that, you're going to make it harder for the company to use it against you. So put that in writing. But always, 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 even if you did something wrong, or even if you did a few things wrong, if you're let go, you call me. Whether you work for 6 months, for 26 years, whether you're old or young, with cause, without cause, does not matter. Big company or small, you call me, because I can almost guarantee you that you have entitlements beyond what the company is saying that you do. All right. So that's why you reach out to me again, employmentlawyer.ca, employmentlawyer.ca. Flo G asks, can I get compensation for hospital bills? No, unfortunately, you cannot get those. All right. Let's see. Next question comes from Bester Lee. Bester Lee. My employer has asked for a number of us to accept a layoff with paid benefits. Otherwise, we will have to resign. I don't want to quit, but I can't afford to stop working either. What can I do? It's like saying if you don't agree to a layoff, you have to agree for me to hit you in the head. No, it's not legal to hit me in the head. They can't make you resign. The only one that can decide to resign is you. So with respect to a layoff, you can say no. And if you say no, one of two things will happen. Either the company backs off and they let you continue working, or they let you go and they have to pay you your full severance. Okay? That's what happens. There's no such thing as resignation. The company doesn't get to decide if you resign. Okay? You get to decide. By definition, a resignation is something that the employee does on their own voluntarily. So it's ridiculous for the company to say, "Oh, I've decided that you've resigned." It's like you going to your employer and saying, "I've decided I'm not the president of the company." Well, you can't do that, right? Because that's up to the company. Well, the same thing with a resignation. That's up to you. So you can say no. Either they decide to let you go and pay you severance, or they back off. If they let you go, you call me immediately, right away. And to reach me, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. So Bester Lee says, so where does the concept of forced resignation come from if it's not allowed? Well, it's not allowed. So for a forced resignation is not legal. It's a termination. So there's no such thing legally as a forced resignation. It's an oxymoron, right? Because a resignation can never be forced. So hopefully that makes sense. By the way, I've spoken a lot about severance. Before I continue answering questions that have come in, let me give you some other information as to how you can find out what is the severance for you. How much severance are you actually owed? So easy to do. You go to pocketemploymentlawyer.ca. You see that address right there, pocketemploymentlawyer.ca. And when you're there, you just click on the severance calculator. Again, severance calculator. That's what it does. That's what the name says. It calculates your severance. It's going to take you a few seconds, and you can find out how much severance you are owed. Completely free, completely anonymous. If you tried to pay for it, you couldn't. There's no way to pay for it. It's completely free. So again, pocketemploymentlawyer.ca. Use the severance calculator, and you'll be shocked, I think, by how much you're actually owed. A lot of people think I get a week per year of service, or I get 2 weeks, 2 weeks per year. All of that is wrong, okay? So pocketemploymentlawyer.ca, use the severance calculator. And if you lost your job or are worried about losing your job, that's the place you go to. By the way, for the last few minutes here, you can ask questions with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I see more questions have come in. I think the best thing I could do is answer them. All right. So Paul C has our next question. Once again, my company is trying to force us back to the office, even after giving me a document stating I was to remain a permanent work from home status. Can they change my status? So here's what happens. You can tell your company, I'm not doing this. I'm not going back. If you tell your company that, one of two things will happen. Either they'll say, okay, fine, we back off, you can stay remote, or they'll let you go. If they let you go, they have to pay you severance. Why can they let you go? Because a company is allowed to let an employee go pretty much for any reason as long as severance is paid. So yes, can they let you go for refusing? Yes. Just like they can let you go because they think your car is too blue. That's a stupid example, but a company can do that as long as they pay you proper severance. So that's what happens ultimately. They can't use that as a grounds to say you've resigned. They can't use that as a grounds to say they can let you go for cause, i.e., without severance. If they let you go, they'll have to pay severance, but they may back off. I can't tell you what they'll do because I don't know them. What I can tell you is if they let you go, you call me immediately, okay? And I'll make sure you get severance. Employmentlawyer.ca, and that's the place to go, and that's the way to reach me. Again, employmentlawyer.ca. So, Besterly, if I do accept the layoff, how long is it allowed to last? Well, here's where it gets interesting. There's actually no right to put you on a layoff. So if a company puts you on a temporary layoff, you may be able to consider that as a termination and get severance. If you don't want to do that, then it's up to the company to decide how long it's going to be, really. But for the most part, if they put you on a temporary layoff and you don't want it, you can consider that a termination and get your full severance. All right. So that's what you have to remember there. And I'll be more than happy to help you if they put you on a temporary layoff, if they let you go, if they say that you've resigned, which is absolutely ridiculous. You reach out to me through employmentlawyer.ca. All right. Alicia has our next question. I was fired for whistleblowing as an independent contractor. What is my position? I'm not sure exactly what you mean about what your position is. Ultimately, it's not about whistleblowing. We don't have really whistleblowing protection in the same way that they do in the States. But unless you're a true independent contractor, you're owed severance. And people are often misclassified as independent contractors when they're not. They're really employees. Happens all the time. So you're only an independent contractor if you're in business for yourself. You have a bunch of clients. You decide what client you're going to go to. You're running a business. That's when you're an independent contractor. If you have a regular job, you're an employee and you've been misclassified as an independent contractor. And if you've been let go, you're owed severance. So Alicia, I need you to reach out to me so we can assess whether you're an employee or contractor and assess how much severance you're owed. Again, employmentlawyer.ca, the place to do that. Again, employmentlawyer.ca. Paul says, my concern is I'm only 18 months from retirement. Now, it's possible, again, I don't know how long you've worked there, your job. It's possible that the severance that you're owed could be more than 18 months. It's possible that they'll take you beyond your retirement date. Remember, there's no way to stop the company from letting you go. It's just about making sure that you get severance. Like I said, you can find out right now, Paul, how much severance you're owed. Just go to pocketemploymentlawyer.ca and use the severance calculator. And again, see that address on the screen, and you'll have what you need. So it's very, very simple. Last question of the day. Again, Lior Samfiru is myself. Let's get one more question in today. I'm currently on a medical leave, and when I saw my doctor yesterday, she showed me something that my doctor found to be disturbing. It was a letter from my employer asking for my detailed medical notes. My family doctor said in her 40 years, no employer has ever or would ever request this. What should I do here? The answer is no, I'm not giving you that. Your employer does not have a right to demand your personal medical information. They don't have a right to know, by the way, why you're off work. They're allowed to know if, yes, there's a medical issue. That's it. Not what the medical issue actually is. That is private. That is personal. So no, you should not give that information. It's private, and they can't punish you for that. So absolutely not. Your employer cannot know your diagnosis, your personal medical condition, what medication you're taking, etc., etc., etc. So keep that in mind. All right, guys, this is the time we've had for today. Lots and lots of questions. I couldn't be happier to have the opportunity to speak to you, to answer your questions, hopefully make you feel better. Now, there's a few of you that I've encouraged to reach out to me. Do that. Don't hesitate. Do that today. Okay, you can do that through employmentlawyer.ca. That address is on the screen once more for you. Again, employmentlawyer.ca. Phone number right there. So this is the email address, fax number there if you prefer. It's all right there for you, or just fill out a form, employmentlawyer.ca. And I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Thank you so much for joining me today. We'll be back again soon, but don't wait until then, all right? Thank you, and we'll talk soon. Bye now.